This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Michael Primeau. Mr. Primeau is the owner of Primeau Forensics, specializing in enhancement, authentication, and recovery of audio, video, and images. He's a sought-after expert witness with over 8 years of experience. Thank you so much for joining me here today.
It's a pleasure to be here. Thank you for the opportunity.
Absolutely. Let's jump into it. You have a background in audio engineering, but it looks like you shifted to forensics. Tell me about your firm and how you became interested in forensic analysis.
Sure. So my father started the firm back when I was a young tyke, before I had the ability to get involved, and saw an opportunity to rise me up through the ranks. I began showing signs of wanting to be an engineer when I was very young, taking apart toys and trying to figure out how they worked. And the meat and potatoes of our business was in audio and video production, but Dad practiced audio and video forensics alongside of that and began growing the firm. And when there was an opportunity to shift more into the digital realm, so when digital audio and video evidence started hitting critical mass, there was more recorders and more cameras and more phones recording evidence. We went full-blown forensics. I began my pursuit in audio engineering back in high school when I started learning more and more about studio recordings and production and playing with microphones and DAWs, and was also a musician. So I pursued an undergraduate degree in audio engineering. Technology from the University of Southfield, Lawrence Technological University, and then began my career in forensics by pursuing certifications through agencies like LEVA, which is the Law Enforcement and Emergency Services Video Association. I have some training from the University of Colorado Center for Media Forensics, and then began getting training in all of the tools that we use to provide digital media analysis. Some of the big names, including Axon, as well as the AMP product line. And as more and more digital evidence started getting recorded, more and more needs started coming to our firm to clarify those recordings, authenticate those recordings.
Along those lines, I'd like to ask you, how do you remain an expert in your field? I mean, this technology is constantly evolving, and, the way that we were doing this stuff 5 years ago, 10 years ago, was completely different than the way that it's happening now. So what does it mean to not just be a forensic expert, but to remain a forensic expert?
Yeah, no, absolutely. That's a great question. And I early on, when I started practicing in video forensics, shortly after I received my degree in audio engineering, best practices were really what we drooled over. People much smarter than us were testing the tools and looking at the back end of how proprietary surveillance is created and how to unpack those recordings and make them more readily available to courts, and to make sure that's done accurately. So agencies like SWGDE, which is the Scientific Working Group on Digital Evidence, really pushed to promote those documents and publish those documents in great lengths, which is where we live, where we rest our hats. I was recently asked on the stand by the attorney that I was working for, what's your opinion? What do you think? And I looked at him, and I looked at the judge, and I looked at the prosecutor, and I said, that's the best part about what we do. It doesn't matter what I think. It matters what the evidence says. It matters what the test result is. It's not put onto my shoulders. I'm just interpreting that information for a trier of fact, for a judge and a jury. So when the technology evolves and we're on the front lines of that, like there's an update with an app, or there's a change in the way that the camera works with the firmware, we have to test that information so we have a known exhibit that we can then compare. An exemplar is what we would refer to it as. But recently I appointed to the video committee. Recently I joined SWGDE as a member, and I'm currently serving as the video committee chair. Which is, I'm so stoked. It's such an honor to be a part of an agency that's generating these documents that I once drooled over at a young age. I started practicing very young, and I testified my first time, I think I was 21 or 22, so scared, going up in front of the court. And best practices have led us through that, because at the end of the day, Again, it doesn't matter what we do. It matters what the method says so that everyone can arrive at the same result. If someone like myself has similar qualifications on the other side, we're going to arrive at the same result in theory.
Let's talk a little bit about those, very first cases when you were young. How did you first? So, you were an audio engineer and you were doing, then you shifted to forensics. But how did this become expert witnessing? What was your very first engagement? Is it something that you were looking for, or did it come at you out of the blue?
It kind of came out of the blue. We were advertising locally as well as nationally with Google. So a lot of our clients today and back then are still new clients that come in from all over the country, looking for investigative work or looking for forensic work. And it was an enhancement case. If I recall correctly, it was a stabbing, and we clarified the imagery so that you could see what had happened better from a distance. And I was qualified as an expert. I had the training to do the enhancement work. And, I asked the attorney at the time, I've never testified, is that going to be a problem? He said, well, everybody has a first time on the
Sure.
stand. And that's, the judge is going to be cognizant of that. They're going to understand that. And that's what the Daubert rules or the Fry rules, depending on what state you're in, really, really come into play. So I was qualified as an expert. I explained to the court, and the prosecutor came out on cross, and he just asked some very straightforward questions. How do you explain this? How do you explain that? What did you do here? And, I answered the questions. I thought on my feet for the most part. And at the end of it, I was passing him after I got off the stand, and he goes, I was really trying to make sure you knew your stuff because I want to use you on another case. And he wanted to use me on the co-defendant's case. So we ended up coming to be retained, and there was no conflict there because it was a different defendant. But we then worked for the prosecutor, and then from there it was all downhill. I was completely blown away that he had asked that question, but started doing more and more work in different areas from enhancement, like doing authentications and comparison analysis. Began working on bigger and bigger cases, and then from there the CV just kept growing, and here we are.
Let's talk about your preparation during those early cases. Did you feel prepared during that very first case and some of your earlier cases to be cross-examined, to write a report, to do all the things that expert witnesses do, or has that kind of evolved? What are the things that attorneys can do to better prepare their newer or first-time expert witnesses?
I think that's a great question, and in answer to your question, no, I don't think I was properly prepared at the when are you really ever prepared to know exactly every single square inch of what someone's going to ask with an investigation? What they're going to ask on cross. But what I've learned over the years is really understanding the method goes further than you would think, depending on the situation that you're in, whether it be a rebuttal situation, whether it be that you're just trying to get an exhibit admitted, whether you're offering an expert opinion. Understanding the limitations of the methodology is really, really important, and making sure that you're communicating all of the aspects of the case, what you did in preparation with counsel, is very, very important. The times where I've left the stand shaking my head going, I really could have done better. Unfortunately, it was due to me and counsel not preparing fully enough and understanding, where cross was going to go, and understanding this little thing, this minute detail that I did forensically that I may not think is important, they may not think is important. We didn't communicate that together so that we were both on the same page.
How has that improved going forward? What are the things that you use these days to kind of counter those possibilities that sometimes happen during a case?
So with every investigation, we generate a list of questions. We go through a list of questions for direct testimony so that, both of us really understand, kind of like a script, but it's more like bullet points. So they know, what we're going to say, what technical terms we're going to use, and
Sure.
then fully understanding any of the weaknesses. So that can be really important. What are the things that we're going to say that might be uncertain in a case? So those limitations, what components may we not have investigated thoroughly enough, and we may have not had that opportunity to do so. So preparation is probably the most important component with any testimony.
Do you ever do mock cross-examinations or mock?
Oh, yeah. Yep, I was just prepping with one of our technicians this morning. It was actually her first time testifying, today, and she was nervous, and over preparing is probably the most effective way to do it. We were told by counsel, there's not going to be a cross. It's a very specific type of case with a very specific type of judge. This isn't your normal kind of encounter. And I said, that's great, but I think it's really important for you to be over prepared in case something happens. You never want to be blindsided when you're testifying with something you don't know. And equally, an attorney never asks a question that they don't know the answer to, in court. That's incredibly dangerous. So I've also worked with a lot of really, really, really good trial attorneys. I mean, people that they just, you ask them a question like, well, what do you think about, what if this happens? And they say, well, this is what we'll do. Like, wow, that's brilliant. That have that 30 or 40 years of hardened experience that can explain to a young punk like me, how it's done. And that's really where you need to have that middle ground. Is where does the forensic meet the legal? Where do those two meet? Where is the intersection point? And how are they going to shake hands? Can they shake hands? So I would say a lot of that is based on experience, and a lot of it is based on the method. I'm always going back to the method, especially as a rebuttal witness. When an expert that may or may not be qualified to do the work is coming in and saying, this is what I see, or this is what I hear, or this is my opinion. And it's like, well, it has to be objective. Otherwise, why are we being contracted? Why are we testifying? Right. And that's where the method shines.
How proactive do you have to be with your attorney in terms of, do you find yourself mainly being passive during preparation and just letting them, inculcate you with the wisdom that you need for the case? Or do you find that you have to question them a lot and figure out where that intersection point is and figure out what the possibilities might be about being crossed that they may have not thought of? Do you feel that you are kind of on the team, or are you just there to answer questions and call it a day?
I think it depends. It depends on the type of case. So at the very beginning of a case, we have a team that will intake all of the notes and the request. So our best practices say, hey, if you're a law enforcement officer and you're going to be doing this in a lab, you're going to get a request from your superior, and it's going to say, can you enhance this license plate, for example?
Mm-hmm.
And if you come back and say, yes, I'm confident in my ability to do so, let's go ahead and process it. You get the recording. And in a lot of cases, civil, criminal, it doesn't matter. The attorney has an abundance of information they want to share. We have to stop them and say, look, in order to mitigate cognitive bias, I just want to know what you need. We'll go ahead and do the testing we need to do. And then from there, we can report, we can draft a report, we can have a discussion, we can prepare for expert testimony. So at the beginning, we try to take that leading step to make sure that the forensic process is protected. And then depending on where the case goes, if it's going to a settlement conference, if it's going to, it's a case going to trial, we can then kind of lay back a little bit and collect some of that information that they're trying to give us. Maybe there's something that needs to be examined in a police report, or witness statements, or a deposition transcript. And then when it gets time to testify, I would say the majority of our clients look to our expertise. They look to, hey, what do you want me to know? Where do you want this to go? How do you want to do this? And then they'll kind of put up a fence or guardrails, like, okay, well, you can go down this road, but I don't want you going this way. I don't want you going that way, because we have legal training. We're required to have legal expert training in our certifications, because we should know and have some training on how to testify. We should know what the Daubert motion looks like. We should know what example cases in the past, how experts have testified in our particular field. But the second we start talking legal, that's dangerous. And so sometimes personally, I have that inclination. I want to try to, speak to those points, but I have to take the legal. No, look, I'm the lawyer. You go ahead and just do your forensic thing, but I'll practice the law, because I'm not a lawyer by any means.
Have you been the target of a significant amount of oppositional research? In other words, do they try to, quote unquote, impeach the witness when you're under cross or during a deposition? And how do you deal with it when somebody says that your expertise is insufficient, or in the wrong area, or you don't know what you're talking about?
My father describes it that you have to have tough skin. You have to have thick skin to be in this business. Yeah, I think the easiest way under the gun, the most effective way under the gun, is you really have to stay focused. I've learned over the years that you never want to follow or try to follow where the attorney's going, whether that be on direct or cross. You want to just answer the question. And you want to be very clear that you understand what's being asked. So oftentimes on cross, I get into these little, I don't want to say tit for tats, but, I ask questions like, they pose a definition, like a word term. And I say, well, if it pleases the court, can you please provide me with a definition? Because that word can mean a lot of different things. And sometimes that frustrates them. Other times they okay, well, this is what it means. What can become very frustrating is when the attorney that's asking you the questions claims to know more than you do, and you really have to take a back seat to that and make sure that you remain calm and you just answer the question you're given, and make sure that if you can prep for that, right, then the attorney that has retained us is going to clean that up on redirect, and you don't have to necessarily worry about those things.
Sure.
So little tips and tricks like that I've learned along the way. One of my most valuable lessons was early on in my career. I had to do an 8-hour deposition, the big firm in Manhattan. And, I was prepping with the attorney beforehand. It was a pro bono case that they took. And he looked at me and said, look, I don't care if you say things incorrectly or you make a mistake. We'll go back and, we'll correct the record if we have to, but don't get rattled. They're going to try to rattle you for the next 8 hours of your life. And you're going to have to sit here and you're going to have to remain calm for that. So we had one attorney working for me, or I was working for. On the other side of the table, you had two attorneys, the client, and then the client's expert. And they were all writing questions on little pieces of note paper and throwing them at the lawyer that was questioning. It was wild. It was the craziest thing I've ever seen in a legal setting like that. And I just had to really stay calm and answer the question. And if they throw a punch, because oftentimes they throw punches or they try to twist things, one of the really valuable things that our best practices agency did is they generated a minimum requirements for training. So, we really fall back to that. Well, isn't it true that, you're not qualified to say this because of X, Y, and Z? And I really fall back on those documents. I fall back on my training. And that way it takes that pressure off me. I don't have to perform in that scenario. But yeah, I've been under fire before, and it's painful working for both sides of the court, working for a prosecutor or working for a civil defendant, a civil plaintiff. Attorneys are going to want to twist things depending on the situation. And unfortunately, that's the way that the legal game works. I don't know if you want to include that. I don't know if they might find that insulting.
Totally.
It's one of those things where, it's just kind of the game that it's a game. But yeah, staying very focused on the question really plays a huge role. And being properly prepped to answer those questions. I had, up until a year ago, I had no idea that there was a such thing as a hard cross and a soft cross. Mm-hmm. So, understanding the difference between those two things and anticipating, well, you're going to undergo a hard cross. So we really got to prepare you for all that. Little nuances like that in prep can make all of the difference. Being very well rested, being very well caffeinated. I learned to testify after lunch. Depending on the lunch, you're usually a little sleepy after. Rest has played a huge role. If I'm a little bit tired that day, I have a hard time focusing on details. And then, of course, depending on the rules, having some sort of notes or report to fall back on. I was testifying last week, and something that I said in a report could have been interpreted a different way. And I kept getting asked that question. And finally I said, can I see my report? I don't remember reading that way. And then I read that statement, that opinion, and looked at the jury and said, look, this wasn't intended to read that way. This word really meant this. And I clarified that for them. And then that 15 minutes of back and forth went away. Let's just go look at the report. And that's okay to do. I've learned that that's okay to stop everything and just make sure that detail is correct. I've looked at the judge and said, Your Honor, I think I made a mistake early on. I need to correct the record with something I said. They'll go back and correct it, if they allow that. So the only way to provide accurate testimony in terms of details in forensic science is more details than anything else is to focus.
Let's pivot to whether or not you accept a client. Do you turn down a significant number of engagements, or do you take most of them?
I will turn down engagements when we are feeling like it's not a good fit to apply the methodology, and whatever comes out the other side is what comes out. So I get a number of clients, both attorneys and both, private citizens or, like insurance adjusters that call and say something to the effect of, I authenticated the recording and I know it's edited. And I look at them and I say, great. Right. So I call them, I say, great. Then I guess you don't need us. You figured it out.
Because that's what we do.
And I'm not trying to be snarky. I'm just saying, that's not what I do. I'm not going to prove what you want to be true. If that's what the evidence reports to me, that's what I'm going to report. But if it's not what the evidence says, I'm going to, so with every authentication case, I make my clients very aware that it could be this or it could be that, and whatever the evidence represents is what I report. So yeah, where there's cases where I'm feeling like I'm going to be a hired gun, or that's what they're really pushing for, and it may not be intentional. They come back and say, no, that's not what I meant, and that's fair. That's just, they have their opinion. But if they're really looking to push their own agenda, forensic science won't work. It just won't work in that situation.
Do you have that kind of ethical, does that come up a lot? Do you frequently have to tell somebody, that it sounds like what you're asking for is unethical, and I can't say that. We're just gonna, I'm gonna do it the way that it needs to be done and let the chips fall where they will.
I would say in phone conversations, I experience that maybe 1 to 2 times a month with new
Oh,
clients.
okay.
It's not very often, it's not something that we get. We probably get that more from some of our private client inquiries that, are seeing like UFOs in their backyard or things like that. They take their cell phone out and they're video recording, and, or this, that, things like that. Or, my favorite one is my DUI tape is out of it. That's a big one we get a lot of, and you ask them how much they blew, and, oh yeah, it was, oh, okay, now I know why you think it's out of it. Right. So, we don't experience unethical situations in court very often. I can only recall one case that's ever happened. And it was an attorney that wanted us to do something unethical. And I said, I don't feel comfortable doing this. I need to do the testing on my own. And they never retained us. They never called back. But a week later, the opposing client called and said, hey, this is my case. And we looked at the legal requirements and said, we're not conflicted. We can go ahead and you can retain us. And that was probably difficult for the other side, but that's
Sure.
the way that it works. So, no, we don't experience ethics violations very often, but my certifications and my membership with the agency SWIG, we do have ethical requirements. So we sign something that says, these are what we're going to be in compliance with. We recognize that there's an ethical requirement as an expert. So I couldn't get paid to do whatever I want, even if I tried.
Let's shift to report writing. Do you frequently get kind of a skeletal outline for a report, or are you typically generating your report whole cloth?
We are typically generating it whole cloth. In instances where we have like a similar case that we've worked in the past, we'll go ahead and revive that as a bone structure to it. The only time that we really ever receive the only time we ever receive something like that is like maybe an affidavit where that jurisdiction has a very specific like template. And in order to be effective with time, we're not going to go back and forth trying to make sure everything looks like it should for that county. The attorney will send something that says, is this an accurate reflection of your report or what we talked about? And then we'll go ahead and influence that. But with report writing, we typically start those from scratch, unless, of course, like I said, we have bones that we can work from our work products here in our office. But reports are definitely a tedious process because we're trying to map out all of those details and get everything in again, because when, it gets time to testify, we've got all that right there. And in some cases, clients don't want that. They don't need a report. They don't want a report in their jurisdiction. It's not requirement for the admissibility of the testimony. But I always make it clear to my clients, we can review reports. I'm happy to change the way things that are worded. I clearly don't speak legal. You speak a different language than I do. I speak forensics. So when I write it down, it might sound a little complicated. When it comes to opinions, those are bulletproof. We don't let our clients influence opinions, but the way things read, we definitely can, go back and forth until we make sure it's clear enough for the court to understand,
Sure. And on, along those lines, your expertise is very technical. How do you bring that down and make it more understandable for laypersons when you're, in front of a jury, for instance? What techniques do you use that something is still, clearly making the case for you, but is also understandable at the same time, and to the attorney who also is not going to be an expert in your area?
I watched a state police officer testify last week, and he was testifying in digital forensics, a practice that we don't do here, a different type of digital forensics. And I remember sitting there thinking, man, I'm having a hard time following him. I wonder if the jury's following. You look over and 2 jurors are asleep, and, they've had a long week at trial, and that's just kind of how it goes. So I try to always intentionally speak slowly. It helps me to also think and make sure that, because there's a lot of stuff you want to say. When you're working a case for months, whether it's on the stand or in a deposition, you always want to rattle a bunch of stuff off, because you want to get this out of your head and make everyone understand what you're thinking and what you've done, and answer the questions and give them as much meat as you can. But I really try, especially on the stand, to maintain eye contact with the jury and to bounce back and forth between the attorney and the jury, and explain those things clearly and slowly. Let's see, what else is there? The 6th grade understanding rule definitely applies to, if I'm using words like concatenate or sine use sola waveform analysis. That nobody knows what that means. No one really cares what that means. They just want to know the rest of what I'm going to say about that. So I really try to also paint pictures. So when I'm explaining metadata analysis and container analysis, I use an example, some sort of like, if you receive an Amazon package, something they can relate to and something the judge can, conceptualize, and
Sure.
it helps. You can see that in your head when you're talking about numbers in computer programs. So I try to use examples as much as possible. I've been told by a lot of my clients, I'm not trying to brag, I'm just saying that this is a useful technique, is making it relatable to real world examples so that you can actually grasp it and retain it. Because if I'm going to talk for 3 hours, I go to sleep too. That sounds terrible to listen to someone like me talk about something that is a fraction of a part in this huge timeline of a case. So
it's not just using smaller words, it's analogizing.
Yeah, it's painting pictures with words, I think, is really helpful, and using illustrations if you can, PowerPoints and exhibits that you print on foam core. And if you have a chance to make a video exhibit and referencing that, or an image exhibit, that can be really helpful. And then, of course, keeping it short. I don't like monologuing for hours at a time. I know when I look over and see someone's clearly not listening to me, and that's okay. That's what the report's for. And so I try to make the court feel like I am not the king of this room. I'm here to help you. That's my job. And
Sure.
You are going to make a decision. Sure, if you ask me my opinion, I may have an opinion. I may not. The judge may allow it. The judge may not. But you're the ones that are going to make this decision. So let me help you.
Before we wrap up, there's a few things that I like to ask everybody. And my favorite one of those is, does winnability factor into whether you take a case? How important is winning to you? Is it something that you take into consideration at all, or do you not care and you're ready to move on to the next one? I've heard a lot of different opinions on that.
Okay. I would say winnability does not factor into whether or not I take a case. I think it factors into whether or not a client will retain us, because I get a lot of enhancement investigations where, well, if you don't get anything, if we can't enhance this, then, will we get our money back, or will you be able to do this? And I say, well, no, I mean, I have to do the work to understand, whether or not something's going to come out on the other end. So what I always try to make clear is I'm only going to take a case if the forensics are going to be helpful, not necessarily helpful resolution, like to help them, but whether or not I can actually apply the method. So when we're doing like a height analysis or a speed analysis, there's a lot of factors that go into an analysis like that. And if the recording doesn't have all of that information and it creates more problems than it does solutions, I'm gonna tell the client those, and I'm gonna say it may not work if this is a picture of a picture of a picture. We're not going to be able to do the analysis because it's not going to be accurate.
Sure.
So I try to make that very clear when I'm retained on a case that, look, if I can't apply forensics, I don't really want to take your money because it's not going to benefit either of us. Another thing I try to push on is, if we're getting pushback on a case with results or whatever, I say, look, my integrity is one component I want to preserve, but at priority is I want to preserve the integrity of your case. Even if I do what you want me to do, it's going to self-destruct in court. And that's the worst place to be in. So let's just go ahead and avoid that. Let's do it, And if it's not a good fit, then it's not a good fit, and we don't have to be getting retained, and that's okay. So no, winnability is not a factor at all for me.
There was one thing that I'd like to go back to that you said that's interesting is that you tend to get hired more or rehired if you win cases or you're on the winning side of a case. Can you tell me a little bit more about that? Is that something that's a big factor? Do you find that rehires are much more frequent when you win? And do you find that, word of mouth spreads and gets you more engagements when you win? Or is that, just one factor among many?
I would say that the majority of our clients are new clients with the
Okay.
infancy of our particular field. A small percentage of our clients come back, years later, because we're kind of like an emergency room. They come to us when they need something, and they
Right.
don't often have like a video surveillance recording in their case. So, I would say helping them through the problem is probably why they would come back, and if they have that problem again. But um, I've had some pretty big, and clients have told me this, that we played a pivotal role in saving their client or winning their client, millions of dollars, or getting them off a death row charge, or whatever the result ends up being. But there is no, that client came back 15 more times after that. That I don't have that experience with clients. So if the forensics wins, I suppose that I get a phone call back, but I don't have a winnability streak, and we work for all kinds of different walks of litigation life. I've been retained by pharmaceutical companies. Even when I told them, you don't need me, you could probably figure this out, they really say, we want you to come down and do this. I've done work for the federal government. I've done work for all walks of courtroom, life, state, federal. So it more so depends on the situation. But in general, even if I did get more clients to come back, I don't get paid more to win anyway. So it doesn't really help me much.
Let's finish up on billing. This is another thing I like to ask everyone because there's a lot of different opinions out there. Do you prefer a project-based billing? Do you prefer hourly? Do you take a retainer?
So with consulting agreements, we typically take a project-based retainer, just because it's a longer period of time that we're working. So we try to get that money at least approved up front, so that we're both on the same page for the scope of that project. For example, like a site inspection, we'll typically provide a proposal that's, I don't know, let's say 2 days of work, travel expenses. We come back into the office and we do some more work, and then we issue a report. When it comes to testifying or investigative work, or the like analysis work that's billed hourly, and we try to put together a package and then have some sort of retainer at minimum up front. But then when you're working a court appointed case, those rules are completely different. So they have a limitation as to what they can offer for an hourly rate. And then in some cases, when you're working a civil investigation, maybe the insurance company doesn't want to cover the fees or that much of it, or whatever. So there's different steps that we take with that.
Sure.
So it depends on the case, but for the most part, if we're providing a service like an enhancement, that's based on an hourly amount, and we try to get that at least approved up front, because some agencies take several months to provide funds. I'm working for sometimes like law enforcement, or where they may have a net 60 return. So we try to be flexible with that, as long as we agree on the money up front. If we're in agreement, we're good to proceed. And then bigger investigations where we're consulting experts, those are mostly packages.
Mike, any last advice for newer experts or attorneys out there that you found to be helpful throughout your career?
I would say that it's always a very enjoyable experience when my clients want to fully understand the work that we do. I think we work more effectively together when they can understand it. Maybe not all of it, maybe not spend months, studying it and reading books and things like that. More so just asking those questions like, well, what about that? I've always wondered, or that statement you made, is there an opportunity for this or that? So working together to have those conversations, because I learned from reading a book recently that we think when we speak to each other, when we have conversation, we're going back and forth like that. It helps both parties to think. So especially when you're in litigation or pre-litigation, or even just building in a couple hours of consulting, just time where we're talking about these things. And if they fully understand at least the core components, it really brings new heights to a case that we can continue to investigate, or we arrive at these conclusions. So I would say just having that interest level is very important.
Sage advice. Thank you so much, Michael Primeau, for joining me here today.
Thank you. Appreciate it.
And thank you to our listeners for joining us for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.